morning and a very warm welcome to all who have joined us today. As they say, your privacy is meant for you, not for others. So why give anyone the opportunity when its protection is in our hands? The topic for today's webinar has a universal relevance, especially in the post-pandemic world that we are living in. Why data privacy is crucial for your business. The UAE has published its long-awaited federal level data protection law, Federal Decree Law number 45 of 2021, on the protection of personal data protection, the PDPL. This came into force on the 2nd of January 2022. I am very much looking forward to the insights that our senior colleagues will provide us today. Just a brief introduction about myself. I am Rahul Datta and I'm Director Marketing at MBG Corporate Services. It is my pleasure to host this webinar today. Along with me, I would like to welcome our esteemed speakers, Mr. Madan Mohan and Mr. Ajay Sachdev. So let us have a look at the agenda today. I will start with giving a very brief introduction on MBG Corporate Services. After this, my colleague, Mr. Madan Mohan, will take you through global privacy regulatory landscape, UAE's bailiwick and multi-sectoral view. Then Mr. Ajay will take you through privacy enhancing technologies in digital economy, MBG's privacy paradigm. And then in the end, we will have Q&A session. So I'm requesting all the attendees to please enter their questions in the Q&A box. So if you click on the Q&A box, you can enter your question and we will try and take as many questions as possible. The questions that we will not be able to answer due to paucity of time, I can assure you that we will be taking these later after the webinar is over. Over the course of the next 1 week, our team will reach out to you and set up meetings with you to discuss this in detail. A brief introduction about MBG Corporate Services. We are a 2-decade-old consulting and advisory firm headquartered in Singapore. We have currently 18 offices across Europe, Middle East, and Asia. We have more than 3,000 clients globally, of which 100 plus are Fortune 500 companies. We have more than 500 professionals and experts employed in all our offices. We have a diverse workforce, as you can see here, and we have professionals from all different areas of expertise. We partner firms from the time they start till the time they reach the maturity level as a business. So we are supporting organizations of all sizes in reaching a certain growth that their founders are looking for. In terms of corporate services that we are providing, we provide audit and assurance services, risk advisory services, indirect tax services. So whether it's related to VAT registration, VAT health check, VAT refunds, excise compliance. Then we have a large team supporting clients on direct tax. So as you're aware, the corporate tax is being introduced from June 2023, and we will be happy to provide you assistance with regard to any queries that you may have on the impact that corporate tax will have on your business. We have a very skilled M&A team with experienced advisors on business restructuring, transaction valuation, working capital management, post-merger integration, and we help companies on both buy and sell side. We have a legal advisory team which helps companies in economic substance review, corporate secretarial services, corporate restructuring, and others. And of course, we have a very specialized technology advisory team, of which 2 senior members are with us on the webinar today, who provide all assistance on cybersecurity assessment, ISO 27001 compliance, information security, robotic process automation, and business process reengineering. We help companies from all industries, and as we are sector agnostic. Now is the time to introduce our first speaker of the day, Mr. Madan Mohan. Madan heads our Technology Risk Advisory Division, and he's a certified Chief Information Security Officer and Data Protection Officer. He has almost 2 decades of experience in servicing public and private sector clients and has done a lot of work with clients like UAE Ministry of Education, Government of Ajman, Al Watfa Insurance, and others. So without much ado, I would like to introduce Mr. Madan Mohan to you and to take this session forward. Thank you.
Thank you, Rahul. Thank you so much for the introduction. And hello, everyone. Very good morning. Welcome again to our series of webinars on data privacy. So today we have included a lot of information on our slides. And hopefully you can use this information afterwards in your daily work to implement data protection law. This time, I'm not starting with my presentation from definition of PII, SPDI, and their categorization, because I believe now you all are aware of these things. However, if anyone wants to know more on PII or SPDI, please send an email, or you may refer our previous webinar, which is specifically for the categorization of personal data. Now, to begin with, as we know, compromised data is the subject that needs utmost attention. Data breaches can result in the loss of millions, even billions of private records and sensitive data, affecting not just breached organization, but also result in compromise of any individual personal information. This slide is self-explanatory. I'm sure it sounds scary. Yes, for me also it is scary because organizations are losing money in terms of fines, legal implication, and most of the time the loss of reputation as well. And for me, the scariest aspect is data breach, which happening in each and every sector, irrespective of size or the location. And cyber criminals use this data against individual in criminal activities. Today, we have audience composition is from different domains like retail, e-commerce, healthcare, financial domain, and the rationale is to secure customer data and avoid such a hefty fines. This will certainly helpful for many of us. Hence, do watch till the end of this webinar. My colleague, Mr. Ajay, will cover many things with respect to data privacy, impact assessment, risk management, and privacy engineering, which will further help you to implement privacy by design and default in your organization. In line to the present slide, the information I have gathered in these many years, I always mention to the management that there are 2 types of organizations that exist in today's world. One, who have been hacked, and second, who are going to be hacked, right? So there are only 2 types of organizations in this digital world, right? Who have been hacked, and second, who are going to be hacked. So take a deep breath and take a baby step at least to implement data privacy in your respective organization. So this is the result of the previous slide, right? I always believe if any organization follows the PPP model, that is public-private partnership in privacy field, then risk of data breach is reduced to an acceptable level. So this slide shows us the commitment and seriousness of government towards data protection. For your information, there are more than 130 countries in the world who have adopted data protection law or some kind of data protection regulation. What this conveys? This conveys that organizations have no choice. Yes, I repeat, organizations have no choice other than to implement data protection law and the best practices for information security and cyber security. Next slide, please. So, as most of you are aware that UAE Cabinet Law has enacted Federal Personal Data Law, which is applicable from 2nd January 2022. This will provide a framework to ensure the confidentiality and security of personal information, outlining the rights and duties of all concerned parties. As known, in UAE, we already have multiple data protection regulations like UAE Central Bank Regulation Rights, DSCC, DIFC, ADGM, but all these are specific to certain locations like free zones or some sectors like financial institutions, healthcare. However, now we got a federal level data protection law, which is applicable to all. Yes, there are some exceptions which we will talk about later in the slide. The new law, which regulates the collection, handling, disclosure, and use of personal data in UAE. However, new data protection law has an enhancement in their governance and transparency obligation that mirror many of the principles of GDPR itself. This slide speaks about consequences if you don't comply the data protection law. DFC, DPL includes the penalties of non-compliances from $10,000 to $100,000. The ADGM commissioner can impose financial penalties up to $28 million. This is one of the toughest penalties in the UAE region. GDPR, everybody aware, the non-compliance goes up to maximum 20 million euro or 4% of the global turnover of that company. UAE ICT healthcare fines up to $70,000. As of now, we are awaiting for UAE data privacy regulation, and penalties are awaited. Now, considering all of these, I strongly recommend organizations to get the data privacy impact assessment done and put the controls to avoid hefty fines. Now, thanks for being here, and I hope you found this informative and also learned the importance of to comply the data privacy law, its benefit and consequences of being non-compliant. And further, on this webinar, let's understand on how we can comply to the laws. I would like to invite my colleague, Mr. Ajay, to take it forward from here and discuss more about UAE data protection law, implementation, risk assessment, and privacy engineering techniques. So Ajay, over to you. Thank you.
Good morning. And now I would like to welcome our colleague, Mr. Ajay Sachdev. Ajay is a certified information system security professional and a certified information privacy manager. He has experience in privacy and information security and has worked in governance, risk and compliance, and cybersecurity domains. He specializes in UAE PDPL, GDPR, ADGM data protection law, DIFC data protection law, and ISMS. So without wasting any further time, I would like now for Mr. Ajay to start the session.
Thank you, Rahul, for the brief introduction, and thank you, Madan, for setting up the floor. So, very good morning, ladies and gentlemen, on the panel here. So, to start with the UAE data protection law, I'll just introduce you to the applicabilities primarily. First of all, so UAE personal data protection law, it applies to the data subjects staying or having in a place of business in United Arab Emirates. It also applies to the controllers and processors within and outside of UAE processing personal information of UAE data subjects. So as Mr. Madan highlighted, so primarily UAE data protection law has been created on the lines of GDPR, but it's a fairly trimmed version of what we see in GDPR. Then where UAE personal data protection law does not actually apply, it does not apply to the government data, government authorities, your judicial authorities. And if any processing is being carried out for personal use, then it is not applicable. It does not apply to healthcare sector. That has been highlighted earlier as well. We know ICT health law that regulates the UAE healthcare sector. Then specific to free zones, again, UAE Data Protection Law does not apply. So we have free zone centric privacy laws. All right. And then the other key highlights we need to look into is that the UAE Personal Data Protection Law is regulated by our UAE Data Office. And primarily it enforces accountability on the data controllers. This is nothing new. Then if we actually talk about the legal basis of processing, so GDPR introduced multiple legal basis of processing of personal information. One of them was legitimate interest, which organizations were using as a basis for processing, whereas in UAE Data Protection Law, legal basis is not a valid option. So that basically means data subject consent is extremely crucial here. There are other categories also, other than the data subject concern, which could be processing in public interest, or if processing is to be carried out to protect the interest of the data subjects, and so on and so forth. So another key aspect is with regards to the adequacy decision. So I hope, again, we refer back to GDPR. Adequacy decision, it's primarily in order to promote business beyond European Union boundaries, beyond the 27 member states within European Union. Adequacy decision as a concept was introduced, which is again based on essential equivalence, wherein two countries, if doing business, if doing any data transfer, cross-border data transfer, then the regulations of privacy should, they should be equivalent as part of protection and confidentiality and security and handling of personal information of data subjects. So now we actually move on to a poll. We need to have a poll.
Yes, so I would like all the attendees to please, answer this poll question. Enter your choice here, and in the next 30 seconds, we will close the poll. So the question is, which privacy regulation applies to your industry sector? So you have to be specific about your industry sector. If it doesn't get covered in these options, then you have to enter other. Another 10 seconds, and then we will close this poll. So these are the results. 44% say they come under the UAE Federal Decree Data Protection Law. Another 44% say they do not come under any of these data protection laws. 6% say they come under DIFC Data Protection Law, and another 6% say they are under the ICT Health Law.
Thanks, Rahul, for that. I think we can move on to the next slide. So we need to primarily look into the applicability of the sectoral view. Yeah. So like we already discussed, the free zones, DIFC, Dubai Healthcare City, ADGM, and your judicial government and police, hospitals and healthcare and government and semi-government entities, they are exempted from UAE Data Protection Law. And whereas all the other sectors shown here in blue, they are primarily, they come under the purview of UAE Data Protection Law. Next, I think we need to look into the international privacy frameworks now. Yeah. So this is going to be a kind of an interesting slide. So we are going to talk about ISO 27701, NIST Privacy Framework, EU GDPR. Just I'll try to draw a comparative view here. So we know ISMS or ISO 27001, that has been a well-known information security framework, global framework, applicable to all regions, and organizations have got their certifications to ISO 27001. So then came ISO 27701, which primarily helps implement personal information management system within an organization. And this will be built on top of ISO 27001. So ISO 27701 cannot be a standalone certification. We need to have ISO 27001 as a prerequisite. And again, this is a management system, what we're talking about. It primarily focuses on the privacy risks in the IT environment. And again, since this is a framework, so there are no penalties associated with it. Next, if we look at the NIST privacy framework, so this NIST privacy framework is, so this framework was introduced in 2020. And prior to this, we already have the NIST cybersecurity framework. So privacy framework complements the cybersecurity framework. And it's a tool for improving privacy through enterprise risk management, right? And it is again a non-certifiable framework, and it will be primarily helping the organizations to strengthen privacy engineering and privacy by design practices. And then we know our well-known European Union GDPR. So that's a regulation. It's not. It's a regulatory framework, right? That's every privacy pro's favorite. So now we see ISO 27701 and NIST privacy framework. These are like risk-based frameworks. But when we talk about European Union GDPR, so is a risk-based approach applicable to European Union GDPR? We need to think about it. When we are actually carrying out data protection impact assessments, or when we intend to hire a data protection officer, we need to look into the high risk processing. That's where a risk-based approach would be required. When we are required to design the security measures applying to personal data, confidentiality, integrity, availability of personal information, so then the risk-based approach would be successful. But otherwise, general data protection regulation is a it drives rights-based mandates. It focuses on data subject rights. It does not otherwise matter to GDPR, and in fact to the UAE personal data protection law as well, because both enforce lawfulness of processing, proportionality, fairness, and transparency principles. Right. So time to answer a few questions. Can we get into a poll now?
Yes, Ajay. So we have the next poll of today. So I'm launching this poll. The question is, do you have a formalized security and privacy risk management program implemented in your organization addressing security and privacy risks?
So to all our participants, we're just trying to have an understanding of your risk management, security and privacy risk management in your organizations. And basis that, we can proceed forward.
So another 5 seconds and then we close the poll. Okay, so let's see the results. So 57% have answered yes, which means they have a formalized security and privacy risk management program, which is great news. But on the downside is 43% saying that they do not have a formalized security and privacy risk management program.
These are good results. So let's dig down deep. We have another poll for you.
Yes, Ajay, I'm starting the next poll. Okay, so the question here is, which implementation risk tier does your company currently fall under with respect to the NIST privacy framework? Please use your gut and respond. There is no, we are not here looking for accuracy, but we are trying to, kind of understand. Okay, another 3 seconds, and then we will close the poll. So these are the results of this poll. 20% say partial, 7% say risk informed, 20% again say adaptive, and majority say here, I don't know. Over to you, Ajay.
Thank you, Rahul. So looking at the results, what we saw in the last two questions, the first question was primarily if we have a security and risk management program. So 53% of us said, yes, we do have. And then the follow-up question was, what kind of risk program are we actually talking about? Where do we stand? Whether we are following in the partial implementation tier, or we're following in the risk-informed implementation tier, or repeatable implementation tier, or probably adaptable. So that's going to be our next slide. And the results were kind of interesting. So 20%, I guess, what I remember, and then 7%. And few of them also said that we don't know. So
yeah, actually almost 57% said they don't know. So it's quite a high number.
Yeah, that's right. So talking about the implementation tiers, see, while we implement a security and privacy risk management program in our organization, right, the depth of a risk management program implemented in the organization will vary. That will vary, and the results actually state that. So when we actually talk about partial risk implementation tier, it primarily indicates that there are no formalized privacy risk management processes in the organization, and the approach is primarily reactive. And the risk management programs are not integrated, and there is limited awareness among the management and among the people working on ground. The data processing ecosystems are, they are there, but again, we do not have any processes to control them. We even don't have visibility in such regard. Data processing ecosystem relationships, limited privacy understanding, and the people on ground, they also have limited understanding of the privacy responsibilities. Next is your risk informed, which is again a slightly step ahead, a bit more progressive, with approved privacy risk management processes in place, but inconsistent actions. Processing happens in silos. There are shared workforce responsibilities, inconsistent actions. And when we actually talk about a repeatable implementation tier, that primarily indicates privacy risk assessments are happening, the processes are approved, they are implemented, they are reviewed, they are defined and documented, and the processes are repeatable in nature, roles and responsibilities are defined, and formally the risks are addressed, and there are dedicated privacy teams, and privacy trainings are also happening regularly. So we are in a good state. But the next, and the optimized version is your adaptive state, wherein we have to be proactive. The lessons that come out of our assessments and our risk registers, we need to implement remediations in such a manner that similar mistakes are not happening again. An enterprise-wide program is existing. The privacy program is there. Risk management program is there. Risk-informed policies and processes are implemented. Senior executive participation is mandatory. So from partial to adaptive, it increases. Then roles and responsibilities, consistency, proactiveness, all these are key visible factors when it comes to any adaptive risk assessment implementation tier. And very rarely, while in the results we saw that some of the organizations said, yes, adaptive, implementation tiers. We belong to adaptive implementation tier. But on ground, when we actually assess, there could be many some differences. So let's move on to the next slide, Rahul. Now we'll actually talk about the data protection impact assessments. So this is an MBG, model of privacy data protection impact assessment that we help our customers with. It's a risk-based tool which helps us understand what personal identifiable information or sensitive personal information is being processed. What purpose, for what purpose the processing is being carried out, who all are involved in processing, if they're vendors or subcontractors, right? There are controller to controller relationships, controller to processor relationships, how the processing is happening, what is the potential impact on data subjects, whether we are going to see any high risk processing, and what all sensitive personal information, is being processed. So all these matters, all these aspects are actually covered when we, perform a data protection impact assessment, and it has to be very thorough in nature. And basis that, we identify the risks and then we plan the mitigations. And going ahead, we have another question waiting for you.
Yes, it's time for another poll. So the question for everyone is, are you practicing security by design and privacy by design in your organization? So the poll is going to be launched now. So here are the results. Ajay, would you like to have a look and then comment on it?
Again, great. It's a great narrative. Well, we see 53% of entities are actually stating, yes, they follow privacy by design and security by design. And then 33% are, modest enough to say, no, they're not. And then 13% of us are saying that we are not sure. So not a problem. So this particular poll will now lead us to our next conversation, which will be on privacy threat modeling. So let's quickly touch upon what is privacy threat modeling. First of all, a privacy threat occurs when we let an unauthorized entity or individual, let them perform a personal information record linked to a sensitive attribute. So if they're able to link a sensitive personal attribute to any piece of personal information, then that will primarily, create a privacy threat. An example here would be location privacy threats. For example, we may end up talking about profiling threats or identification threats or tracking of our locations. So, and then on screen, what you see are primarily the privacy threat models, which are prevalent in the industry. A privacy threat model is primarily a proactive approach used within technology applications and solutions developments, and which will help identify privacy risks proactively and enforce privacy by design and by default, which is a privacy requirement. So we will not be able to take all these, but I'll primarily pick the first one, which is Linden. And again, this is a known model. So Linden is an acronym. L stands for linkability, then identifiability, non-repudiation, detectability, disclosure of information, unawareness, and non-compliance. So these are the set of 8 parameters which are primarily utilized to perform threat modeling from privacy perspective. It is primarily used by the analysts when systematically identifying and mitigating privacy threats in software architectures. Well, all the security pros on the call, they would have also heard of another threat modeling technique, which is your STRIDE. STRIDE, wherein we talk about spoofing, tampering, repudiation, information disclosure, denial of service, elevation of privileges. So these are all the threats. Again, when we are doing security threat modeling, so STRIDE is an option. And then from privacy perspective, we are talking about Linden here. Another one interesting in nature is your plot for AI. That primarily stands for Privacy Library of Threats for Artificial Intelligence. This is a newly introduced threat modeling technique, which primarily is a threat modeling library to help build responsible artificial intelligence-based solutions. Next, let's talk about few of the privacy enhancing technologies. So over here, what do you see? Homomorphic encryption, secure multi-party computation, differential privacy, zero knowledge proofs, obfuscation, pseudonymization, data minimization. These are well-known terms when we technology folks, they talk about privacy, and the future is all about the privacy enhancing technologies. So we will just pick zero knowledge proof. What is primarily zero knowledge proof? It's a cryptographic method by which one party can verify another party without asking for additional information. An example would be identifying the verification of an individual. So probably if we want to verify the age of a person, we may not have to ask for the date of birth. So it helps conform to privacy requirements of data minimization, data protection, and privacy by design. And then homomorphic encryption is another one. The application of homomorphic encryption lies with cloud service providers to promote privacy preserving data analysis. Encrypted personal information using homomorphic encryption is not required to be decrypted in order to be processed. So next we move on to the MBGs data protection framework. So our experienced privacy and information security industry experts can assist, with implementation of information security. So we have experience with information security management system implementation, then cyber security assessments, penetration testing, source code review, and vulnerability assessments being carried out. So then from privacy perspective, what you see over here is a data protection lifecycle model wherein we are helping our customers implement a privacy program from creation and collection stage to disposal stage of personal information. We help our customers build and implement a privacy program, all covering people, process, technology, carrying out data protection impact assessments, identifying privacy risks throughout the personal information lifecycle, helping with mitigation recommendations, maintaining records of processing activities. So maintaining records of processing activities is a mandatory ask. And then preparing data protection agreements for any cross-border data transfer kind of arrangements, privacy policies, cookie policy, privacy notice, etc. And then following this, we will move on to our implementation and sustenance approach. And well, I've already talked about the privacy program. So from initiation to compliance audit, wherein we do the gap analysis, and then we help design and implement the privacy policies in the environment. The most important and key aspect is that we need to maintain the benchmark that we achieve. The most important, and we are not supposed to drop below that compliance level. We offer periodic compliance audits, services, and privacy maturity assessments, and virtual DPO services as well, to offer governance support and share the burden of the enterprises. So, I mean, from my perspective, that's the whole agenda that I plan to cover. But a closing remark I would want to make that privacy is an individual's right, and every enterprise has the obligation to respect and protect that.
Thank you so much, Ajay and Madan, for that very insightful and informative presentation. I'm sure it has been a very useful, 45 minutes, which our participants have spent here. And we have received a lot of questions, during the course of this webinar, and even during the process of registration, we received a lot of questions. So the first question I would like to ask Madan is, how will ISO 27001 certification help in compliance to the UAE Federal Decree Data Protection Law?
So ISO 27001 certification is, you can say it's an information security certification, right? Which talk about how you can secure your information, right? Now, information could be your organization related or the personal data related, right? But if you set the baseline to protect your system, application, database, right, and you follow the layered security mechanism, that will make a baseline of your security. And after that, you can implement the data privacy law, right? And in each and every data privacy law, whether it is DIC, ADGM, or new data privacy law, talk about information security, right? So anyhow, you have to implement this ISO 27001, right, which complement your data protection.
Thank you, Madan. We have now a question which I think Ajay would like to answer. How do you think DPIA and threat modeling are different?
Thanks, Rahul. So we must do a data protection impact assessment when we plan to process, any high risk personal identifiable information. You can use the screening checklist to help and decide upon the process of data protection impact assessment. Primarily, data protection impact assessment is a compliance and risk-based approach, wherein we are trying to understand what kind of personal information and we are going to process, what is the purpose of processing. And, so primarily when we do a data protection impact assessment, we first do a dipstick view. It's a kind of a quick PIA. Then we proceed on to a more thorough data protection impact assessment if the situation demands. Whereas when we actually look at the threat modeling techniques, they are more to enable IT solutions to address privacy by design and by default while creating the solutions. So we talked briefly about Linden and Stride and the other, privacy enhancing technologies.
Thank you, Ajay. I think it's almost time, so we would, take the other questions later. Thank you so much to all our participants and to our esteemed speakers, Madan and Ajay. This has been a very engaging session, and I hope all of you have found this useful and informative. We will continue to organize many knowledge sessions like this in the future, so do follow us on our LinkedIn, Instagram, YouTube, Facebook, and Twitter channels. Thank you once again and wish you a happy weekend.